Welcome back, everyone. Here is a newer video on Dimwitte DeWitte. This is the audio recording of his sentencing by Judge Kraynick. The overlay is random video since there was no video recording that I found of it. Hope you enjoy.
All right, we're back on the record. Madam Clerk, can you call the DeWitte matter, please?
2023 CF 843, State of Florida versus Jeremy DeWitte, State.
Ryan Zephyr, State of Florida.
Defense.
Joseph Zwick.
All right. Mr. DeWitte, good morning. Can you please raise your right hand? Madam Clerk's going to go ahead and swear you in.
You can sit down. Do you solemnly swear or affirm that the testimony you shall give shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Sir, can you state your full name and date of birth for the record for me?
Jeremy Charles DeWitte, 21080.
All right, I understand that we were here on a motion to sever that's being abandoned for the purposes of a plea. What do we got, Mr. Zwick?
Your Honor, Mr. DeWitte is going to plead guilty to counts 2, 3, 4, and 5. Those are all third-degree felonies. The state has agreed that on counts 5 and 4, Mr. DeWitte will be adjudicated and sentenced to 60 months Department of Corrections. Count 3 will be consecutive to counts 4 and 5, and he'll serve 30 months Department of Corrections. Count 2 will be consecutive to counts 3, 4, and 5, and Mr. DeWitte will be placed on 3 years of probation. As a condition of probation...
Count 3 was consecutive or concurrent, I'm sorry.
Count 3 is consecutive to 4 and 5, and then count 2 is consecutive to 3.
Got it. With 3 years of supervised probation?
Correct.
Got
and
it.
As a condition of probation, Mr. DeWitte will have to pay to USAA restitution in the amount of $9,490.
Give me that restitution amount more time.
$9,490.
0 cents?
Correct.
Uh-huh.
He will be eligible for early termination at the halfway point if all money is paid and there are no violations. There will be court costs, cost of prosecution, and cost of defense. The costs will not be reduced to a judgment lien at any point. This sentence will run concurrent to any other active sentence which is currently being served. We're aware of Mr. DeWitte serving a sentence for federal court in the Middle District of Florida as well as from Osceola County, and there's a cost of investigation of $5,489.55, which will not be a condition of probation but will not be able to be reduced to judgment lien at the conclusion of the probation.
Okay. Got it. State, is that an accurate representation?
It is accurate, Judge. I could approach with an order for investigation costs and restitution deemed.
You may. Score sheet stipulated too, sir?
The score sheet as well as the factual basis, and the state will be dropping count 1.
Okay, got it. All right. Mr. DeWitte, good morning. Sir, in this case, you've been charged by way of information, count 1, organizing, planning, or participating in an intentional motor vehicle collision. That's a second-degree felony, punishable up to 15 years in the Department of Corrections, and it carries with it a 2-year minimum mandatory sentence. Do you understand the maximum penalties associated with that charge, including the minimum mandatory?
Yes, sir.
As to counts 2, 3, and 4, you've been charged with false and fraudulent motor vehicle insurance counts 2 and 3, false and fraudulent motor vehicle insurance application. Those are both third-degree felonies, each punishable up to 5 years in the Department of Corrections. Count 4, false and fraudulent insurance claims, a third-degree felony, punishable up to 5 years in the Department of Corrections. And count 5, failure by a sexual offender to comply with registration requirements, a third-degree felony, punishable up to 5 years in the Department of Corrections. Do you understand the maximum penalties associated with those charges?
Yes, Your Honor.
Sir, if we were to proceed to trial on counts 2, 3, 4, and 5, and the state proved that you were guilty beyond a reasonable doubt, the lowest permissible sentence would be 87.98 months in the Department of Corrections. Do you understand the lowest permissible sentence?
Yes, Your Honor.
Your lawyer tells me that you wish to change your previously entered pleas of not guilty and enter pleas of guilty as to counts 2, 3, 4, and 5. Is that what you want to do today, sir?
Yes, Your Honor.
Are you under the influence of any drugs, medications, or alcohol?
No, sir.
Are you currently taking any medications or prescriptions?
Heart medicine, Your Honor, sir.
When's the last time you took that medication, sir?
This morning, Your Honor, sir.
Is it affecting your ability to perceive or understand here today?
No, sir.
Have you ever been diagnosed with a mental illness or emotional disturbance?
No, sir.
Do you believe you're suffering from either of those two things here today?
Not today, Your Honor.
How far did you go in school, sir?
I'm not for you.
Can you read and understand English?
Yes, sir.
All right, sir. I hold in my hand a 4-page document entitled Plea Form. Do Did you have the opportunity to review and understand this before you signed it?
Yes, sir.
Did you have the opportunity to go over it with your attorney?
Yes, sir.
Did your attorney answer any and all questions that you may have had?
Yes, sir.
Has your lawyer done everything that you've asked of him to do in this case?
Yes, sir.
Is there anything your lawyer did not do that you wanted him to do?
No, Your Honor.
Are you satisfied with his representation of you in this matter?
Yes, sir.
All right, sir. In looking at the plea form on the first 3 pages, there's a portion that says defendant's initials. To the left of each one of those marks, initials appear. Did you affix your initials to those parts?
Yes, sir.
Turning to the last page, sir, top right-hand corner, pointing to it now, there's a portion that says defendant's signature, and a signature appears. Is that yours? Similarly, sir, bottom left, there's a portion that says defendant, pointing to it. Signature appears there as well. Is that also yours?
Yes, Your Honor.
All right, sir, do you understand that by entering into this plea, you are giving up certain rights?
Yes, sir.
You're giving up the right to plead not guilty, the right to trial by jury, the right to representation and assistance of counsel, the right to compel the attendance of witnesses on your behalf, the right to confront and cross-examine witnesses against you, the right not to testify or be forced to incriminate yourself, the right to remain silent. And should you invoke that right at trial, I would instruct the jury that they cannot hold that against you in determining your guilt in this case. The right to challenge the state's case by filing pretrial motions, and the right to be presumed innocent until the state proves you are guilty beyond a reasonable doubt. Do you understand that you are giving up all these rights by entering into this plea? Are you entering into this plea freely and voluntarily? Did anyone force you, threaten you, or coerce you to enter into this plea?
No, sir.
Other than what your lawyer has placed on the record here today, has anyone promised you anything else?
I'm hoping he's going to explain the rest of the stuff later, maybe before we're done.
When you say rest of the stuff, what do you mean?
The probation.
So he's talking about conditions of probation. So they're not asking for any additional conditions. There's no curfew under probation. Typically, you'd be allowed to travel. I'll cover any of those particulars. Yeah, we'll get to those details. It just hasn't really come up yet because it's not. The state's not asking for any.
It's going to be in the 11th to require sense of tendencies in jail.
That's what I was discussing before about the Jennifer Lunsford Act with the ankle monitor. Probation is saying you would be getting an ankle monitor on probation due to the previous sex offender conviction. That's outside the scope of what the court can do.
I can't change those conditions, sir.
I know that when he was on probation before, he said he did not have one in the same position. But I guess that's one of those things. Like, you got to cross that bridge when we get to it. But the court can't. The court's not the reason you would be getting it if it does happen.
My only question would be, and I'm sorry to take your time.
You're fine.
This would restrict me from just. It's not like I have to be home.
No, you're not going to be in control.
So then I can go wherever I want. I'll just have the box.
Typically, that's correct. Yeah, there's not going to be any conditions that restrict your travel. If you go internationally, we may have to file a motion to get permission to do that. But generally, your condition of probation, isn't going to prohibit you from working and going interstate or inter-county for work.
Okay.
And if anything does happen, it can be addressed to modify any conditions.
That won't change.
Right. So some of these issues may not be an issue until you become on probation. But then at that point, just about anything can be resolved. But there's no condition prohibiting any of that in this plea.
Does that answer your question, sir?
Yes, sir.
Has he answered any and all questions that you may have asked?
That's it.
Are you satisfied with his representation of you in this matter? All right, sir. Do you understand that by entering into this plea, we will not have a trial, and I will sentence you according to the terms of the plea?
Yes, sir.
Are you entering into this plea freely and voluntarily?
Yes, sir.
Did anyone force you, threaten you, or coerce you?
No, sir.
Again, other than what your lawyers explained to the court today, has anyone promised you anything else?
No, sir.
Mr. Zwick, have you reviewed all of the discovery provided by the state and reviewed the nature of same with your client?
Yes, Your Honor.
Are you aware of the existence of any physical evidence containing DNA which would exonerate the defendant in this case, Mr. Stokes?
I am not, Your Honor.
Mr. Zwick?
No, Your Honor.
Sir, are you aware of any DNA evidence which would show that you're innocent?
No, Your Honor.
All right, factual basis stipulated?
Yes.
Courts reviewed the original arrest affidavit and subsequently filed information, coupled with counsel stipulation, finds there's a sufficient factual basis. Sir, I accept your plea. I find that you are alert and intelligent, that your plea has been freely and voluntarily made, that you understand the nature of the charges against you, been represented by competent counsel, whom you say you're satisfied, and I find there's a factual basis for accepting the plea. State, you have an announcement to make.
State would announce that all process to count one and will follow up in writing.
Any legal cause why sentence should not now be imposed?
Not from the state, Your Honor.
Defense.
No, Your Honor.
All right, sir, I accept your plea as to count 5, failure by a sexual offender to comply with registration requirements, and count 4, false and fraudulent insurance claims. I adjudicate you guilty. I sentence you to 60 months in the Department of Corrections with any credit time served that Madam Clerk will provide to you momentarily. That sentence shall be followed by the acceptance of your plea of count 3, a false and fraudulent motor vehicle insurance application. I adjudicate you guilty, sentence you to 30 months in the Department of Corrections, consecutive to the sentence imposed as to counts 4 and 5. As to count 2, I accept your plea as to the charge of false and fraudulent motor vehicle insurance application, adjudicate you guilty, sentence you to 3 years of probation, which shall be consecutive to the sentence imposed in counts 3, 4, and 5. Other than the standard conditions of probation, restitution shall be ordered in the amount of $9,490.00. That shall be made in monthly payments of not less than $210 per month. You will be eligible for early termination at the halfway point of your probationary term, so long as all restitution amounts have been paid and there's been no other violations. You'll be responsible for all court costs, costs of prosecution, costs of investigation, the amount of $5,489.55. Those amounts shall not be reduced to a judgment lien. This sentence shall be concurrent with any and all other active sentences. The sentences imposed as to counts 4 and 5 shall be concurrent with each other. Madam Clerk will give you your credit time served and the totals of all court costs, costs of prosecution, and costs of investigation at this time.
The time served is 684 days. The total court costs are $6,157.55.
Any position as to the payment of those amounts, those will not be a condition of probation.
I don't think that jail credit is correct. So I can calculate. I don't know what the calculation, but I know that he was in jail for about 6 months, bonded out, and then was re-brought back over here. He has it calculated up to like 700. And what is it?
735. They violated my bonds, even though they filed motions to you 4 times, Your Honor. But the judge in Osceola did violate my bonds for this charge April 11th of the year that I was arrested.
That way was your
So I have that he was arrested January 19th, 2023, bonded June 27th, 2023, so it's 160. And then the bond was revoked in Osceola April 12th, 2024, until today, it's 5/24.
You said June? I bonded up in July. I didn't bond up in June from this.
That's not what he said.
So what I would suggest is let's run it, calculate it. We need to make sure that we're on the same page. If it's wrong, I've got a window I can motion to correct it.
He's got 30 days.
So we'll have to chat and fix that. If there is an error, I'd have to go do some math, which takes a long time. So
If there's a miscalculation, counsel has 30 days to file a motion, and we can address it if there's an error in regard to the calculus. Okay? All right. Any position as the payment of those court costs, cost prosecution, and cost investigation?
I'd ask for 5 years once he's released from custody to have everything paid in full.
All right, sir, you'll have 5 years for your release from the incarcerative sentence in the Department of Corrections to pay those amounts in full. You'll have to report to probation within 2 business days of your release from your incarcerative sentence. Do you have any other questions for me, sir?
I'm sorry, Your Honor.
Sorry.
So when you're saying consecutive, those consecutive sentences will still be concurrent to everything else?
That's correct.
Okay. All right, so basically that just falls in.
So the 60 months is to counts 4 and 5 will be concurrent with each other. They'll be followed by 30 months, which is consecutive to the 60. Those incarcerative sentences shall be concurrent with any other sentence that you're serving. Okay?
And my last thing, Your Honor, I'm sure nobody will be here in 5 years. I'm sure you all will get better jobs and move on and not going out here. But my biggest concern with this, I'm taking this deal out of because it's in my best interest. I don't want to say anything that's hurt my deal or mess anything up. Mr. DeWitte has done a very good job. My biggest concern is my wife and my daughter in Egypt at this current point. They're living in our home in Egypt. So my daughter's 5. When I finish this sentence, I'm going to go home. And the way this is structured now, because of it being an illegal sentence, because that's what they were communicating about the illegal sentence, my biggest concern is maybe you'll be the judge. I don't know. But when I violate, because I hope I won't, but when I do.
Wait, did you all hear that? When I violate. Guess he knows himself as well as we do.
I'm hoping that somebody pays attention and doesn't, because I can't get all the jail credit when I violate. So that's going to be a problem for me, because then if I violate, instead of getting the credit towards that time that I violated, then I'm going to turn around and doing another 5 years with my wife and daughter stuck in Egypt while I'm stuck in jail, instead of getting the time served that I'm going to be doing applied as a dream case, if I'm saying that right, applied towards my probation violation. I hope I'm not going to violate. I truly do. But I'm not aware of this court's. I'm a nobody. I'm a loser. I get it. I'm nothing to Orange County and the state of Florida. I get that. But I don't know if this court is very aware of who I really am and what I've been through. The deputies that I've had fired, the probation officers that I've had suspended for a year, and the deputy that killed himself because of the charges that they were going to file against him for what he's done to me. So my biggest concern is going on probation with a target on my back the size of the United States, and I'm going to get violated for the simplest technicality, and I'm scared that I'm going to go in front of a judge. Thank God that Judge Wooten saw that last time when they did the same thing for something I couldn't control. They violated my probation for a YouTube channel that was hacked, and the money was stolen by was stolen.
I can't tell you what's going to happen in the future. All I can tell you, sir, is that the terms of probation will be explained to you. You'll be given to them in writing. Your lawyer can go over them with you as well. Every case is different. Every issue is different. If there's a violation in the future, the court, whoever it is, whether it's me or my predecessor or successor or whoever, is going to have to address what that issue is, if it arises. I can't tell you what's going to happen. I can't tell you how it's going to play out. I can't tell you if you're going to violate or not. I have no idea. I don't know what tomorrow holds. All I can tell you is that if and when we get to such a situation, it will be dealt with accordingly. That's all I can tell you. I can't tell you anything more than that. Anything else, sir? All right, sir, you'll have 30 days from today to appeal the judgment and sentence in writing. If you cannot afford attorney, one will be provided to you. I'll now remand you into the custody of the Orange County Jail to transfer you to the Department of Corrections for the completion of your sentence, and I wish you the best of luck.
Thank you, Judge.
Yes. Hang on. Wait. Hang on. Madam Clerk may be correcting the credit. We're redoing some math. Hang on.
So it looks like he was in Pinellas County, and then he got transferred to Orange. So by making 733.
Okay, so Madam Clerk has redone his calculus. Apparently there was a period of time, sir, where you were in Pinellas County Jail. Adding that in, Madam Clerk has determined it's 733 days in credit time served. Okay, all right, so the court will revise the sentence to the 733 days of credit time served. Again, sir, you'll have 30 days from today to appeal the judgment and sentence in writing. If you cannot afford attorney, one will be provided to you. I'll now remand you into the custody of the Orange County Jail to transfer you to the Department of Corrections for the completion of your sentence, and I wish you the best of luck. Thank you.
I never meant for things to go this far. I'm sorry for what I've done. But Sergeant, that's not me.
Thanks for watching. Much more to come. Please remember to hit the like if you enjoyed and want more.